In October 2023, a city council in southern Brazil passed a law none of its members knew had been written by a machine. The bill was a municipal ordinance exempting Porto Alegre residents from paying costs associated with water meter replacements. It moved through the chamber without controversy, received sufficient votes, and became law. The councillors who approved it believed they were acting on human-authored legislation. They were not. That case became public. Most do not. In at least 6 U.S. states, AI-drafted policy language has entered legislation without lawmakers knowing the origin of the text they voted on. Across multiple national governments, AI tools are processing public comment submissions, generating bill summaries, and producing early draft language, functions performed with little to no public disclosure. The staffers feeding information to elected officials are increasingly routing that process through generative AI systems that leave no trace in any legislative record. The technology being adopted without governance frameworks is being used to produce the governance documents themselves. Laws regulating artificial intelligence, the statutes meant to define what AI systems can do, who they affect, and who bears responsibility when they cause harm, are being shaped by the same category of technology they are written to constrain. No rule in any U.S. legislative chamber currently requires disclosure when AI tools assist in drafting a bill. No procedural change is needed to introduce AI-generated language into statute. One person with a commercial AI subscription and a policy goal is sufficient. The democratic system processes the output the same way it processes anything else. Porto Alegre City Councilor Ramiro Rosario typed 49 words into ChatGPT. The prompt asked for a bill preventing the municipal government from charging residents for water meter replacements. A complete legislative bill appeared within seconds. Rosario made no edits. He sent the text to no legal aid for review. He introduced the bill to his 35 colleagues without disclosing its origin, shepherded it through the chamber, and it passed. When the origin became public after the vote, Rosario confirmed the facts and explained his prior silence directly. If he had revealed the bill's AI origin before the vote, the proposal certainly would not have been taken to a vote at all. The concealment was not an oversight. It was a calculated decision made by an elected official who determined that transparency would produce rejection. The bill's substance was not without civic logic. Water meter replacement costs fall disproportionately on lower-income residents, and the ordinance addressed a real financial burden. But the mechanism that produced the law, a 49-word instruction to a commercial AI system, zero human revision, zero disclosure, is the part that demands examination. No special access was required. No legislative rule was violated. Rosario used a publicly available tool, submitted its output through standard channels, and the institution processed it without resistance. Democratic procedure functioned exactly as designed, operating entirely on the false premise that the document before the council was what it appeared to be. This is what makes Porto Alegre significant beyond its local jurisdiction. It demonstrated that the distance between a generative AI system and an enacted law is exactly as short as one official is willing to make it. Porto Alegre produced a clear documented case because its councillor eventually admitted what he had done. The harder problem is the volume of what goes undisclosed. In 6 U.S. states, AI-drafted policy language has entered legislation without lawmakers knowing the origin of the text. Those 6 represent cases where tracing was possible. Generative AI outputs carry no watermark, no metadata flag, no embedded signature identifiable to a colleague or a constituent reading the enrolled bill. The actual number of affected legislative texts is almost certainly larger. Governments are using AI tools across the full life cycle of legislation. These functions include summarizing lengthy bills into briefing documents, scanning large volumes of public comment submissions to identify themes, flagging potential legal risks in proposed language, and producing early draft text for policy staff. Each function was previously performed by human analysts whose work was, at minimum in principle, accountable to the institutions that employed them. The shift to AI assistance has occurred without commensurate public disclosure. Researchers at Seton Hall University documented in 2026 that there is rarely a clear statement disclosing when a bill analysis or policy recommendation was generated or assisted by AI. Citizens engaging with the legislative process assume human beings reviewed the submissions they sent to their representatives. That assumption is, with growing frequency, incorrect. The opacity is not confined to drafting. When an AI system processes thousands of public comments submitted to a state agency and produces a summary for a legislative committee, the choices embedded in that summarization carry political weight. Which themes get elevated? Which concerns get compressed into a subordinate clause? Which arguments get categorized as representative of broad public sentiment? These are judgments with consequences. No public vote governs the design of the system making them. Congressional offices in the United States receive constituent correspondence at volumes that strain human review. The Congressional Management Foundation estimated in 2023 that some offices receive more than 1 million constituent contacts per year. AI triage of that volume has a practical rationale, but when an AI system determines which letters receive substantive responses and which receive form replies, it is deciding whose concerns reach a legislator's attention. That decision is not neutral, and it is not publicly disclosed. As Lawfare and the Harvard Kennedy School noted in a 2025 analysis, routing legislation through an AI system requires no committee approval, no public notice, and no amendment to chamber rules. A single legislative assistant making a private choice to use a generative AI tool is sufficient. The decision is invisible, unilateral, and without institutional consequence. Rosario expressed no remorse. He expressed satisfaction. The bill passed, the policy goal was achieved, and the technology had functioned as a faster drafter than any human aid. His defense rested on outcomes. The ordinance was substantively reasonable, the process was efficient, the result was law. What his defense did not address was the procedural foundation of democratic legitimacy. Legitimacy is not only a function of whether a law is substantively good. It derives from whether the process that produced it reflected the authorized will of the body charged with making it. A council of 36 people voted on a document under false premises. The member who introduced it knew the premises were false and managed that knowledge strategically. The council's collective judgment, the instrument with the democratic mandate, was bypassed by the representative himself. Other legislators, confronted with questions about AI use in their offices, have framed their answers around workload. AI helps manage volume. AI helps staff keep pace with the demands placed on under-resourced offices. AI helps produce initial drafts that humans then revise. These characterizations are not fabrications. They describe how AI tools function across many government offices, but each carries an embedded assumption that human review is substantive, not merely procedural. The Porto Alegre case offers one data point against that assumption. Research on human-AI collaboration across multiple industries offers a broader pattern. When AI systems produce confident, structurally coherent, well-formatted output, human reviewers apply less critical scrutiny than they would to a peer's draft. The cognitive friction that generates meaningful revision is reduced. The reviewer becomes a co-signer. The AI's language persists into the final document with minimal alteration. When that pattern plays out in legislation, the human name on the bill conceals the actual origin of its content. The legislator sponsors it, defends it, and votes for it. The AI system that produced the foundational language does not appear in the public record. The accountability structure points at a person. The authorship does not. The framing of AI as a neutral drafting tool, a faster, tireless legislative aid with no agenda, rests on the claim that the system has no preferences. That claim does not survive scrutiny. AI systems are trained on data. That data has a composition, a historical distribution, and embedded priorities. A system trained on past legislation learns what legislation has looked like, which problems it addressed, whose interests it centered, what language successfully encoded those interests into statute. When that system drafts new legislation, it reproduces the architecture of old legislation, problems with no historical analog, constituencies whose concerns were never centered in prior policy, legal frameworks that existing law has never considered. These are precisely where trained-on history systems produce their weakest and most conservative outputs. Researchers at Seton Hall University stated the structural consequence directly in 2026. AI systems trained on historical data tend to reinforce existing norms and power structures, making new or unpopular viewpoints more likely to be filtered out. This is not a malfunction. It is the predictable result of systems optimized to produce language resembling successful prior examples. In legislative terms, successful prior examples are the laws that passed, not the laws that should have passed, not the laws that were blocked by concentrated opposition, not the laws that were never drafted because no one with drafting resources had an interest in writing them. The conflict of interest extends to the companies whose tools are being used. OpenAI, the company whose product Rosario used to draft the Porto Alegre Ordinance, maintains active lobbying operations in Washington, D.C. and Brussels. Its commercial future depends directly on the regulatory environment that AI legislation creates. Google DeepMind, Anthropic, Microsoft, and Meta share that dependency. Their tools are being used to draft and analyze the regulations written to govern them. No formal conflict of interest framework has been applied to that relationship. No disclosure requirement names it. When a public comment process receives submissions from industry groups, environmental organizations, individual residents, and academic researchers, and an AI system trained on prior regulatory proceedings categorizes those submissions for a legislative committee. The categorization is not apolitical. Prior regulatory proceedings have systematic patterns in how different submitters were weighted. A system trained on that history will replicate those patterns. The residents whose comments are compressed into a footnote rather than a substantive finding do not know an algorithm made that choice. They followed the public process. They have no recourse against a system whose design choices they cannot examine. In credit scoring, when an algorithm produces discriminatory outcomes because it was trained on historically discriminatory lending data, that is litigated as algorithmic bias. When a legislative AI produces policy outputs reflecting historical legislative bias, the mechanism is identical. The legal and regulatory vocabulary to address it has not yet been applied. The question of who authors legislation has never had a clean answer. Lobbyists draft language for sympathetic legislators. Think tanks produce model bills, adopted verbatim across multiple state houses. Legal staff write entire statutes presented under their employers' names. The ideal of the deliberating representative crafting law from democratic principle has always competed with institutional and economic influence over the legislative product. AI in the drafting process does not introduce that problem. It removes the friction that previously made the influence visible. A lobbyist's draft requires a human relationship, a meeting, a traceable chain of communication. A generative AI output requires a prompt. The same influence over legislative language now operates faster, cheaper, and without the institutional footprint that made prior influence at least theoretically traceable. What AI introduces that is structurally new is unverifiable authorship. When a lobbyist drafts bill language, there is a person with identifiable affiliations, financial interests, and a position in an accountability chain. However imperfect that chain has functioned in practice. When a generative AI system produces a draft, the accountability chain terminates at a commercial product whose design choices are proprietary, whose training data is not fully disclosed, and whose outputs carry no signature in the legislative record. Several proposals have circulated among legal scholars and technology policy researchers. The most frequently cited is mandatory disclosure when AI tools materially assist in drafting legislation. The same logic that applies to financial conflict of interest filings. The practical difficulty is enforcement. No reliable method currently exists for detecting undisclosed AI use in legislative text. Stylometric detection is inconsistent and defeated by light editing. A second proposal applies conflict of interest frameworks to software, prohibiting AI systems built by companies with direct financial stakes in AI regulation from being used to draft or analyze AI-specific legislation. This requires defining which legislative activities qualify as AI-adjacent, a categorization that expands as AI capabilities extend across policy domains. A third approach, advocated by researchers focused on democratic integrity in regulatory proceedings, would subject AI summarization tools used by government agencies to the same public notice requirements as the regulatory actions they support. The system performing the summarization is, in this framing, itself a policy instrument and warrants equivalent scrutiny. As of mid-2026, none of these proposals have been enacted in any U.S. jurisdiction. The European Union's AI Act, entering enforcement in stages from 2024 onward, addresses high-risk AI applications but contains no provisions specifically governing AI use in drafting the legislation meant to implement it. The gap between adoption speed and governance speed is a consistent feature of technology transitions in democratic societies. What distinguishes this instance is the domain. The technology being absorbed without adequate oversight is being used to generate the oversight documents. The absence of disclosure rules in legislative procedure is not a gap in some distant regulatory domain. It is an absence that directly benefits every party with an interest in the current situation continuing. Rosario's 49-word prompt and the enacted law it produced in seconds are the minimum viable illustration of a process already operating at scale without visibility inside legislative bodies whose authority derives from the informed consent of the people they represent. The people electing their representatives do not know their laws may have been written this way. The representatives voting on the laws sometimes do not know either. The systems generating the language have no stake in the outcome and no capacity to bear responsibility for it. What law says determines what power does. Who writes the law determines what the law says. When that authorship becomes unverifiable, the accountability on which democratic systems depend becomes, in the precise meaning of the word, fictional.